coming in. Rajiv Dhawan says, let the MLAs appear before the Deputy Speaker. We will inform the Deputy Speaker about the proceedings here. That much I can assure. So Rajiv Dhawan, who's the lawyer for Deputy Speaker, says, let the MLAs appear before the Deputy Speaker. So the Deputy Speaker wants the MLAs, the rebel MLAs from the Shinde camp to come to Mumbai so that they can appear before the Deputy Speaker. And Rajiv Dhawan says, we will inform the Deputy Speaker about the proceedings here. That much I can assure. Kamath says, no court has ever granted a stay of disqualification process. The proceedings of the House will be interdicted. The Solicitor General says, may I say something? Kamath says, I don't know how Solicitor General is interested in this. This is very strange. Kamath refers to para 6 of the 10th schedule to say that the disqualification proceedings shall be deemed to be the proceedings of the Assembly till a final order is passed. There is no question of judicial review and no question of interim order. He says, this is Advocate Kamath. SC now is mulling an interim order. Mr. Kothari.
Yes, absolutely. See, this is Mr. Devdutt Kamath's argument. But the Supreme Court is not going to buy this simply because the power of judicial review extends everywhere to all the proceedings. If there is a doubt about the legitimacy of the appointment of the Speaker, are you trying to tell me as a Supreme Court that I cannot look at that? Obviously, the Speaker was legitimately appointed unless and until he takes a decision, yes. Until then, I will not be able to intervene as a Supreme Court because there is a separation of powers doctrine. But when the appointment itself is in question, when you yourself have appointed, when you did not have the numbers, which is the argument of the Shinde camp, the Supreme Court obviously has to intervene in this. So they will have to give a stay. There is no question about it. Unless there is a statement by Mr. Rajiv Dhawan on behalf of the Deputy Speaker that no decision will be taken. If he gives an undertaking that no decision will be taken until July 11th or until the proceedings conclude here with the Supreme Court, then there is no question of any stay because the party himself has said that we are not going to decide upon anything. So the question, what the Mr. Rajiv Dhawan is trying to do is he does not want a Supreme Court interim order going in favor of Shinde's camp. That is exactly what Mr. Uddhav Thackeray's camp is going to try, and that any lawyer would try who's having the brief. Now, whether or not the Supreme Court buys that, I'm sure the Supreme Court will not buy that. Otherwise, 5:30 p.m. is the deadline. So
okay.
You have to
Abha Singh, notice also to Sena Chief Whip Sunil Prabhu, who was recently appointed.
See, as I said when we were earlier discussing that Supreme Court is the apex court, to say that you go first to the High Court, that we cannot be taken, Supreme Court can come in. But the bigger issue here is that we have a division of powers in this country, the pillars of democracy, the parliament,
okay,
the assembly.
The judge is saying, I'm sorry to interrupt. Abha Singh, just coming to you, I'll let you finish your point, but the judge says this is justice stance. We have to ensure that this proceeding does not become infructuous, something that Mr. Swapnil Kothari was saying. So are we now going to see an interim stay? Abha Singh, yes, you were saying something.
You know, the thing is very clear, but what you have to see is what did the Shinde camp ask for? On 25th, they questioned the disqualification of the Deputy Speaker. But the issue is, they had the Deputy Speaker before that had only issued them a notice saying that you have not come for the party and by you should not be disqualified. The issue is of the 10th schedule where they all have defected. They are sitting in Guwahati and the merger, if they don't merge. So I think they're trying to bite for time because on one hand, they don't want to leave their Shiv Sena membership.
That is only one side, ma'am. That is only one side, ma'am. You have to consider what the judge has now said. The ultimate jurisdiction of Speaker is in question here. The Deputy Speaker's position is being questioned here. Swapnil Kothari.
Yes, exactly. That's exactly what I'm referring to. That if the Speaker was legitimately appointed, then the issue would be that whether or not the Supreme Court is going to grant a stay to the legitimately appointed Speaker, whether to act upon the disqualification notice or not. Obviously, the court will not interfere. The court will say, sorry, the Deputy Speaker has been legitimately appointed. He can decide upon that. If he decides the wrong way according to you, then you come to us. But before that, don't come to us. But when the Speaker's appointment itself is in question, obviously, I as the Supreme Court, as the final arbiter of the Constitution and of everything that pervades within it under Article 32, without bypassing 226 or even after bypassing 226 for the High Court jurisdiction, jurisdiction. I have the powers. Otherwise, why have Article 32 itself? That is what the court is going to say. And even on top of Article 32, I have Article 142, under which I can pass any order as the Supreme Court to do complete justice. That is not going to come into the picture here because Article 32 itself suffices here. So the constitutional question of whether or not I have the power of judicial review, of course the judicial review is considered as the basic structure of the Constitution. And you cannot take away that from me, especially when the jurisdictional aspect of the Speaker itself.
Right, we are yet to hear the final word on this, but Neelashish, very quickly, sum up the arguments so far, or also the notice issued to the 5 sides, including the Chief Whip, should come as a major relief to the Shinde camp.
Well, definitely the court has admitted this by clearly issuing notices and seeking a response in 5 days. The main 2 questions here again remain. One, whether the Deputy Speaker can in fact take up the motion for removal or disqualification of the rebel MLAs when his own position has been questioned. That is still the main crux, because the interim order on that basis will entirely seemingly change the game. Because if an interim stay is granted, that is what the Shinde camp had moved Supreme Court for. They did not want this proceeding to take place. They had stated that the amount of time given to them is also incorrect, that the manner in which the Deputy Speaker issued the disqualification notice is illegal, is arbitrary. So that, of course, till the 11th of July will be deferred, and no action can be taken till then. And
legal
that
editor
would
sending us more updates. Neelashish, hold your thoughts. We feel status quo should continue as this petition must survive on merit. Status quo, says the Supreme Court. This is big breaking input, breaking first on Times Now. Massive relief for the Shinde camp. This is big relief. Swapnil Kothari, something that you were referring to. The court is saying that we feel status quo should continue.
No, that's a very logical, order passed by the Supreme Court, that until unless we hear arguments, complete arguments from both the sides, and until we decide the petition on merits, obviously the status quo should continue. And what is the meaning of status quo? That the disqualification notice, as it were, should be hanging in abeyance until unless we come to the conclusion that the Speaker has been legitimately appointed. So that is what the relief will be to the Shinde camp as far as this aspect is concerned. And obviously, see, this was for asking simply, Pranesh, because the Shinde camp was the one that moved the court first. You cannot have a disqualification notice hanging over your heads and not move the court. Obviously, that was a step taken, and the law is for the vigilant. So obviously, the Shinde camp was vigilant enough to approach the court first, saying that, putting up the entire picture before the court, and then the court has to agree. And even if it was the Uddhav Thackeray camp, if the situation was reversed, then Uddhav Thackeray camp would also get the same relief, because 5:30 p.m. deadline expires. So it is not the question of which camp. It is the question of who is right as far as the interim procedure.
Okay, here is what Harish Nair tells us, our legal editor, as an interim measure, time granted by the Deputy Speaker to the petitioner or similarly placed MLAs to submit written submissions by 5:30 p.m. is extended to 5:30 p.m. on July 11th. So massive relief for the Shinde camp. They have now time till July 11th.